All right, good afternoon, everyone. We're back on the record. This is First Appearance Court, and I'm Judge Jackie Powell. When I call your name, I'm going to ask you to come up, and then we will talk about whether I found probable cause, and if I have, then we'll talk about release conditions. So I'm going to begin this afternoon with Nicole Egan.
She's here, present, Judge.
All right, good afternoon, ma'am. You're before the court for count one is a violation of felony probation, which is a no bond hold. And then count two is an out-of-state felony hold, which is also a no bond hold. You should be going to extradition court next Tuesday or Thursday. Good luck, ma'am. Okay. Oh,
Next case on the docket, I think, is Miss Secure Blackwood, her mom's.
okay. All right, on page two, Shanika Blackwood.
Blackwood's here at Main, Judge, and she is approaching. Come on up, ma'am.
Good afternoon, ma'am. You're before the court for one count of failing to stop or remain at an accident involving non-injury. Count two is careless driving. Count three is failure to provide proof of liability security. And four is an expired tag, less than 6 months. And the court does find probable cause, and does the parties wish to be heard as to bond?
Your Honor, the state will be requesting a $1,500 bond.
Judge, and speaking Miss Blackwood, my understanding this is her, she has a clean record. She is a registered voter here in Broward County. She's a mother of a 9-year-old, her daughter. She lives with her husband. Judge, she's an aspiring actress. She lives locally here in Lauderhill. Judge, considering if the state can verify she has a clean record, I'm going to be asking the court to consider an ROR. If not, then a $1,500 or $1,000 bond would be reasonable.
Good afternoon, ma'am. How are you? Are you Miss Blackwood's mom?
Yes,
What is your name?
Marie Lilly.
Miss Lily, did you want to say anything to me in regards to this?
Yes.
Just about the bond, not about the case. You can
Okay.
only, today's not the day to talk about the case.
Okay. Is she gonna get bond today, please?
Well, that's what we're discussing. Did Ms. Blackwood have priors? Oh, okay, all right. Um, Then I will ROR Ms. Blackwood.
Thank you, Judge.
Very much.
All right. All right, ma'am, thank you. She'll
All
be
right, thank you
released
so
on her
much.
own recognizance, and she just has to pay attention to when she has to come back to court. All right. Someone is signed in on Patrick Gibbons, who's on page 11.
Okay. He's here, Judge.
I'm sorry,
And
Mr.
approaching.
Reedy, what did you say?
I haven't had a chance to look at the report on this. It is not
Okay,
in
well-
Odyssey,
Oh,
and it's a pretty serious allegation, so.
all right.
I don't know if-
I'll recall it when the attorney's ready, okay?
Thank you.
All right. Now Madam Clerk, do you have the docket? I usually don't go by the docket, but I just wanted to see.
Gibbons, and the booking is, Devin, the booking's wrong on Clarissa Jones.
All right, next on the docket is Clarissa Jones,
Paul Ryan, I believe.
okay? Ms. Jones, good afternoon.
How you doing?
I am okay, ma'am. You're before the court for two additional charges. Or is it burglar with assault or battery, and count four is a petty theft?
Actually, Your Honor,
Are
count
they
three was upfiled from burglary of an occupied dwelling to burglary with a battery.
Okay,
Count four was actually upfiled to from theft to robbery by sudden snatching. If you have a copy of the capias, it's reflected there. I know on the booking, it
yes.
says theft. That being said, originally her bond on the burglary was set at $5,000, Your Honor. I'm gonna ask that that bond be kept in place on the even though it's a punishable by life offense now. I am gonna be requesting a $2,500 bond on the robbery by sudden snatching. A no contact order, I believe, is already issued. Well, I would ask that, obviously, any
the
conditions
previous
that was previously
conditions?
set be kept in place.
All right, so Ms. Jones, you're before the court. You were before me before, but they've now increased one of the charges to burglar with battery. And then the next charge has been upfiled to a robbery by sudden snatching no weapon. So it's from the same circumstances, but just the nature of the charge has been changed, okay? So as to count three, I am going to impose or reimpose a bond of $5,000. And then on the robbery by sudden snatching, I'm gonna impose a bond of $2,000. That she, okay.
All right, I'll make that phone call for you, Ms. Jones.
Okay, thank
Okay,
you.
All
good
right,
luck.
good luck, ma'am.
Mhm.
All right. Then Veronica Roman.
Ms. Roman is here, present, Judge of Maine.
All right, Ms. Roman, you're before the court for 4 counts of felony violation of pretrial. Those are all no bond holds and not for magistrate. And then count 5 is a grand theft charge. I do find probable cause. And your bond is $1,000. And you also will be in court tomorrow in your felony division at 8:30. Good luck, ma'am. Next, we have Brian Russell.
He's approaching, Judge. He's here at Maine. Come on up, sir.
Mr. Russell, good afternoon. You're before the court for 1 count of DUI. And the court does find probable cause. Does the parties wish to be heard as to bond?
No request at this time, Judge.
All right, I have $500 is the bond. Good luck, sir. Jonathan Mascola.
Mr. Muscola, come on up. He's here at Maine, Judge.
Okay, Mr. Mascola, good morning, good afternoon.
Good morning. Good afternoon.
Count 1, resisting without violence, and count 2 is trespassing, not a structure or conveyance. We did, and the court finds probable cause.
Judge, and speaking Mr. Muscola, he's interested in trying to see if the court would consider resolving this matter today.
Okay. Does the state have an offer for Mr. Muscola?
The adjudication, time served, no return.
He wishes to accept the state's offer, Judge.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down, sir. Do you understand the proceedings you're in today?
Yes.
Is anyone forcing you to resolve your case?
No.
Do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for a mental or emotional illness?
Yes.
Is there anything about that that is affecting your decision making today?
No.
Do you understand that you have the right to go to trial, that by taking a plea you are giving up that right?
Yes.
And do you understand that if you're not a U.S. citizen, that by taking a plea it could subject you to immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence will be adjudication and time, credit for any time served, and no return to this location in Hollywood. Okay? Do you understand
Okay.
that? Okay, good luck, sir. How about Carrie Godwin?
Mr. Godwin is here present, Judge Amain. Come on up, sir.
Mr. Godwin, you're before the court for misdemeanor capias on a possession of cannabis 20 grams or less charge. Who's the judge on this? If there's a no bond,
I believe it's Judge Merrigan.
It's at a veterans court, Your Honor.
it's Veterans Court. Oh. All right. Well, I think Mr. Godwin's got to go back to Veterans Court.
Judge, I understand that, and I did advise him most likely that's what's going to happen, but I know this is a cannabis offense misdemeanor, so I'm asking the court to consider an ROR.
I'm positive Judge Merrigan had his reasons.
Right, Judge Merrigan put a no bond hold on it. So I'm not going to make that change. We'll just try and get him into court as soon as possible. All right, good luck, sir. Omar Oliveros Lopez.
Ma'am, I'm gonna.
All right, Mr. Lopez, you're before the court for one count of DUI, and count two is a DUI with a balance greater than .15. The court finds probable cause.
Judge, Mr. Oliveris has been here almost half of his life, and what he advised me, he's never been arrested, not even a speeding ticket. So, Judge, I'm going to ask for an ROR. If the court's not inclined to a straight ROR, I just ask you to leave the bond in place.
Yeah, I'm going to deny the straight ROR unless he wants pretrial supervision.
No, I'm going to contact his family. Thank you, though, Judge.
Okay. Owen Fowler.
Mr. Fowler is here, present, Judge Amain. He's approaching. Come on up, sir.
Mr. Fowler. You are before the court, counts 8 through 15 are fraudulent use or possession ID of another person without consent. And then count 16 is a petty theft. And the court does find probable cause.
Judge, Mr. Fowler is requesting to be released ROR on 6 through 16.
What is, Mr. Fowler's bond status on the other counts, 1 through?
He has a VOP on hold. He's been in custody since January 9th.
That's gonna be denied. The bonds are, $1,000, 1 through 15, and then count 16 is $750. Good luck, sir. Johnny Eugene? All right, Mr. Eugene is, before the court. Oh, this one from this morning is we've added, it was reset to add charges. So count 1 is a possession of cannabis 20 grams or less. Count 2 is possession of heroin. Count 3 is possession of cocaine. Count 4 is resisting without violence. Counts 5 and 6 are felony violation of community control. Counts 7 and 8 are felony violation of probation. The court does find probable cause, and I'm gonna leave the standard bonds in place on counts 1 through 4. Counts 5 through 8 are no bond holds, and my notes indicate he should be before his felony judge tomorrow at 9 a.m. Good luck, sir. So this one that you gave me back, but they added, it was reset to add charges, so you wanna put, that's the one from this morning. All right. No, because those are, yes, yes, yes. Donald Calcote,
Bonder, Judge?
Jason Richmond.
He's here at Maine.
Mr. Richmond, you're before the court for count 1, possession of methamphetamine. Count 2 is possession of GHB. Count 3 is possession of drug paraphernalia. Counts 4 is a traffic violation not for magistrate. Count 5 is a felony violation of probation, which is a no bond hold. And my notes do indicate that you should be before your judge tomorrow at 8:30. And I will leave the standard bonds in place on counts 1 through 3. Good luck, sir. Ricky Pierre,
Here is bonded, Judge?
all right?
On Harrison, three shouldn't even be there anymore, right?
Craig Siderio,
I believe he's in North Broward. North Broward.
Mr. Siderio, good afternoon. Sir, you're before the court on 1 count of possession of MDMA. Count 2 is a felony violation of probation. Count 3 is also a violation of felony community control. Those counts 2 and 3 are no bond holds. The bond on count 1 is $1,000, and you should be before your felony division judge tomorrow at 8:30. Good luck, sir.
Yes, thank you.
Eric Loy.
He's here present, Judge at Maine.
Okay. All right, Mr. Lloyd, good afternoon. You're before the court for 2 counts. Count 1 and 2 are felony capious matters that are no bond hold and not for magistrate. Counts 3, 4, 5, 6 are felony violation of community control. Counts 7 through 16 are felony violation of pretrial. counts 17 through 24, felony violation of pretrial. Those are all no bond hold, and, I don't know, well, this said that you were in court this morning, or should have been in court this morning in your felony division. I don't know if that's true. Were you there?
Yes,
Okay.
ma'am.
All right. All right, then, sir, good luck. Mr. Patrick Gibbons?
He's approaching, Judge.
All right. So, Mr. Gibbons, you're before the court for one count of carjacking with firearm or weapon, and counts 2 and 3 are grand theft charges. They're all felony charges, and, I do find probable cause as to the bonds.
State would be seeking a no bond hold on count 1 upon the finding of proof evident or presumption great, relying upon the juvenile transcript affidavit prepared by Detective Saldana of I think this is the Coconut Creek Police Department, Your Honor. I would note this is a direct file case. The state investigated the matter as well and determined these were appropriate charges to file.
And we would object to the court making a finding of proof evident presumption great. Whether the state decided to file the charges or not, that's just an indication that they have a good faith belief in a likelihood of conviction. Doesn't mean that they feel the case is so strong as that it could reach the very high standard of proof evident presumption great, which after my review of the affidavit, I don't believe it can. There is really no other evidence against Mr. Gibbons other than this facial reconstruction process that they went through. There's nothing in here that indicates how it was that the school came up with some type of suspect that matched Mr. Gibbons' physical appearance. I think that the identification process in this case is very much subject to attack down the road. And while I agree it should be enough for the court to make a finding of probable cause, I do not believe that it is enough to establish proof evident presumption great on this 17-year-old man. So I would ask the court to set a bond for Mr. Gibbons, and until we can find out more about this identification process, he should be released. And maybe Mr. Romero can provide more background into Mr. Gibbons.
And Your Honor, I can tell you, since Mr. Reedy brought it up, I do have a supplemental report where the victim states that at some point during his interaction with Mr. Gibbons, Patrick Gibbons shared that he's a student at Monarch High School. That is what led law enforcement to reaching out to the school resource officer at Monarch High School.
Okay, I've reviewed the probable cause affidavits again, and I do find probable cause. There was a description that was given to the police officers for them to be able to create this photo lineup. And so I am going to make a preliminary finding of proof evident presumption great. As to count one, I'm sorry, I know, are you both the parents?
Yes.
Good afternoon.
Good afternoon.
All right. It's always difficult to be in this, at this juncture,
Yes.
but I appreciate you being here. So as to count one, I am going to make a finding of proof evident presumption great. At this point in time, it's a preliminary finding. And so what that means is that even though I'm going to issue a no bond hold at this time, there is, under case law, State v. Arthur, where his attorney can file an Arthur hearing with his presiding judge for them to, for further consideration to set a bond, okay? So there'll be no bond on count one, and counts 2 and 3, the bond will be $1,000.
Your Honor, I'd request no contact, please.
No contact with the alleged victim in this case until further order of the court. Thank you. All right, Clinton Tripp.
I believe Conti.
Yes, ma'am. Conti.
Yes, ma'am. Clinton Tripp.
Mr. Tripp, you're before the court for a petty theft, third or subsequent offense. It's an additional charge. I do find probable cause. Is Mr. Tripp being held on other counts?
He's got a $15,000 bond on a robbery with a weapon.
Okay. So I'm gonna leave the bond at $750. Good luck, sir.
All right, thank you.
How about Mr. Mingo today? Do we have him?
Still a medical reset.
All right. Anthony Harrison.
Conti, Your Honor.
All right, Mr. Harrison, you're before the court for one
Yes.
count of aggravated battery causing bodily harm. This is upcharge?
No,
No.
he came before the court originally, Judge Murphy, on kidnapping. We filed a different type of kidnapping. They're all
Oh, I see.
kidnappings are still PBLs, and it's a different type of aggravated battery, but still aggravated battery. I don't know if you have false imprisonment on your findings, Judge.
I do.
We know, you can OPC and ROR that, we know info that count.
All right. So now he's only facing the counts 1 and 2, which is the aggravated battery with the bodily harm. And then count 2 is the armed kidnapping.
Yes, and as you can see, Judge Murphy found proof evident or presumption great on the kidnapping originally in order for him to be held no bond. Instead of $5,000 bond on the aggravated battery, I would just ask that those same findings be imposed at this time.
So 5,000 on count 1 and no bond on count 2.
Yes, ma'am.
Sure, we objected at the time Judge Murphy made those findings, so I'll renew those objections.
Okay. And all the previous conditions were no contact?
I believe so.
Yes. All right, Mr. Harrison. And then on the felony docket, hearing docket, we have Christian Sirius. On the felony hearing docket.
No problem.
Okay. Mr. Sirius is before the court. There was an arrest in November, and then this current arrest is January 7th. He's here for a 30-day motion for release.
So what happened, Your Honor, was he was originally given pretrial, and then he was arrested on a violation of pretrial.
Okay.
And now he's been in over, I guess, 30 days, probably plus some. That information has not been filed at this point, Your Honor. He's entitled to release.
All right. Do I have those orders?
Does that clear things up for you, Mr. Sirius? Now you know exactly what's going on with your case.
From what I know, it's very confusing.
All right. So let me tell you, you're before the court for a 30-day motion for release because the charges have not been, information has not been filed. And today you're before me, the information still has not been filed. So I'm granting the motion for your release. It doesn't mean that the state can't file the charges. They can file it later on. Now it's going to be on you to pay attention to your mail so that you can see if the charges have been filed and if they've been filed, when you have to come to court.
Yes,
Okay?
ma'am.
All right. Good luck, sir.
All right, good luck.
Thank you.
Heather Kelly.
She's out of custody, I believe, Judge. It looks
She's
like she
out?
was on pretrial release.
Heather
Oh,
Kelly.
no, I'm wrong. Hold on.
It says something about a per email.
All right, Your Honor.
Okay.
Heather Kelly Lewis.
Heather, well,
It's me.
Yeah,
That's me.
it's the second look on a felony, Your Honor.
yes.
When she was arrested, she had an outstanding capias on a petty theft. That was pled out. Still has a $1,000 bond on the grand theft. I believe the court's concern was that, while, failing to appear on one theft-related matter, then picking up a felony theft-related matter.
Excuse me, Your Honor, but it was on the same charge. I didn't get a new charge. It was all on the same time, at the same time. I don't know why there was a grand theft on there, but I went to court yesterday and I pleaded out, and it should all have been one. I don't understand why I'm still.
Well, it's not one. What was your sentence yesterday?
I put in no contest and I would pay the fine of $257, but I never got arrested on anything else. So it was on pretrial, did the pretrial, and they told me it was
No,
reduced
okay.
petty theft.
Miss Kelly, hold on, all right?
Yes, ma'am.
You went to court yesterday and you resolved a case. What was your sentence?
I pleaded no contest.
Right.
And I got the $257, and I would never go back to CBS again.
Okay, all right. That's it. That's all you need to say right now. Were the items recovered from J.C. Penney? Do we know?
I'll check that, Judge.
I've never been to JC.
Hold on.
Yeah. I did that old charge from many years ago.
She has a bond on this case, $1,000?
Yes, ma'am.
And, let's see. No, that's why it was filed as a not in custody. Looks like she said she selected just under $800 worth of betting items. She fled in a Kia. They caught the tag number. She's the registered owner, and the witness, I guess that was a loss prevention officer, ID'd her from a double-blind photo lineup.
Judge, it seems she's not going to be able to make $1,000 bond, or she would not still be in. I'd ask the court to consider pretrial release.
I do have a job. I work in season here. I have two elderly parents that are 83, and I do all the driving and caretaking for them. I've not done anything since then. I not even a traffic ticket. I make sure they get to the hospital, Holy Cross.
All right.
My father
All right,
has.
Miss Kelly, stop talking.
I'm sorry, ma'am.
I'll release her to stand her pretrial supervision.
Thank you, Judge.
Thank you, ma'am.
All right,
Thank you, Judge. Thank you.
Make sure you
Joshua,
check in tomorrow. We'll give you one
Yes,
back.
ma'am.
you gotta go to pretrial tomorrow, and make sure you sign up.
Yes, thank you. Thank you, Your Honor.
All right, good luck. Joshua Runyon.
He's here, Judge, at Maine. Come on up, sir.
All right, Mr. Runyon is back for a second look on his bond status.
Correct, Judge. He has $1,000 bond on a possession of cocaine charge. He lives in Fort Lauderdale with his mother. His mother is on disability. From what he informed me, his mom can't afford to post his monetary bond. Now, he is working. He washes cars for a living. He does have priors, but from what he told me, it's been about a year. So, Judge, we're going to be asking for the court to consider releasing Mr. Runyon on pretrial release.
One moment, Judge. Okay. From what I can tell here in Broward, his history is 2015, resisting with violence, 40-month state prison as a habitual offender. 2011, possession of cocaine with a VOP, 16.5 months state prison. 2011, burglary of a dwelling, grand theft, just grand theft. VOP, 16.5 months. 09, possession of cocaine with intent to sell or distribute within 1,000 feet of a school or child care facility. Most of his arrests also have either included new offenses or he was out on a case when he got arrested and had his bond revoked or was picked up on a violation of probation. So I do have a concern about him following release conditions.
All right, I am going to, I will do a level 2 pretrial and also added to random testing.
Yes, Judge.
How about Cachet to Nort?
He's in Paul Ryan, Judge.
All right, Your Honor.
All right, I've re-reviewed the probable cause affidavit in this case. I am not going to make any status change at this time.
Judge, she is, if I'm not mistaken, looking at BSO pics, it looks like she's on pretrial release already on all the counts except count 4, where she has a $5,000 bond.
Try release?
No, Your Honor, Your Honor set a $5,000 bond combined with pretrial?
Yeah, no. I was the one who, I saw her before. No.
Yeah, you wanted both in place.
Right, okay. All right, I'm not gonna make any change at this time. Bernard Carroll?
North
Good luck.
Broward.
I'm done?
Yes.
Okay.
Bernard Carroll?
North Broward, Judge.
Yes, how are you, Your Honor? Bernard Carroll presiding.
Hi, Mr. Carroll.
How are you?
I'm good. Mr. Carroll is back for a second look on his bond status.
Yes, Judge, he has a $1,000 bond on the grand theft. I spoke with his sister a while ago. He is welcome to come live with her. He works with her. She has her own business as a property manager. He's been living here in Florida for the last 5 years. He can stay with his sister. They spoke last night. She made very clear what conditions she would want Mr. Carroll to abide by if he was to come and stay with her, including but not limited to getting some counseling for drugs. So I would consider asking the court to ROR Mr. Carroll to his sister's custody.
Just so the court's aware, in the 5 years he's been living in Broward County, he's already gone to state prison as a habitual offender on, well, it's a little over 5 years, but 3 separate cases, one for burglary conveyance, another for retaliating against a witness or victim, and a third for armed burglary of a conveyance. He's gone to prison for possession of PVP. He's got a battery conviction, a felony theft conviction last year, and he just got arrested 2 days before this arrest for panhandling.
If the court's not going to consider a straight ROR, I'd ask you just to leave the bond in place, Judge.
All right, yeah, I'm not gonna grant a RO.
I understand. All right, I think your sister may be able to bond you out, Mr. Carroll. I'm not sure, but I think so.
You spoke to her
Yes, I did.
just recently?
Yes, since I
Ernest?
spoke to you.
Ernest
Is there any-
Montes?
Is there any
In
chance
jail.
of a pretrial?
No, sir, not at this time.
Okay, well,
Mr.
thank
Montez,
you.
Judge Maine?
I'm sorry, okay, Mr. Montes. Mr. Montes, is also back for a second look. He was arrested on February 24th.
That is correct, Judge. He has a $1,000 bond on a misdemeanor resisting without violence and a tampering. My understanding is Mr. Montez does have priors, but from what he advised me, he's been out of trouble since about 2010. He is a trainer. He's working as 2 kids in which he has shared parental responsibility with the mother of his children, in which he helps out financially, Judge. Right now, Judge, there's no one that's going to be able to afford to post his bond. I'm asking the court to consider releasing Mr. Montez on pretrial release.
And I believe the court's concern was you were being advised where he was going to reside, and the underlying allegations in this case, what led to law enforcement getting involved, was they responded to a domestic disturbance complaint where Mr. Montez's stepfather wanted him removed from the property.
And Judge, and speaking Mr. Montez, just to avoid further complications, he won't go back to that location. He can live with his father. There are other places where Mr. Montez can live, but Judge, right now, no one can help post his monetary bond, so we're going to be asking the court to release him on pretrial release.
All right, does Mr. Montez know where he's going to stay?
judge know the address, sir.
1697 Northwest 193rd Street, Miami, Florida 33169.
All right, Mr. Montez will be released on level 2 pretrial.
Thank you, Judge.
All right, can we have Christy Burchick?
Paul Ryan, Judge.
Good afternoon, Your Honor.
Good afternoon, ma'am. Well, you look better today than when I saw you
Yes,
before.
ma'am. Yes, ma'am. Sorry, I was really tired.
Ms. Burchick is actually on both the misdemeanor and felony docket,
Oh,
Judge.
she's on both dockets?
Yeah, she has a total bond of $2,500, which she is not going to be able to post. Is that right, Ms. Burchick?
That's right, sir.
Do you have a place to stay?
Yes, I do. It's 321 Northwest 39th Street, Pompano Beach, Florida. 33. Do we keep going?
Who lives at that location?
My fiance, my husband, and I, and another roommate.
Is it your husband or your fiance? Which one?
Well, he's my husband, and the other, there's two gentlemen that live there. And yeah, it's like, I'm being honest.
Are you married or not, Miss Burchick?
I'm married to one of them.
What about the other one? The other one's not your fiance, is it?
Well, he's taking over the boundaries of the husband's not doing.
All right, Ms. Burchick, you look better than when I saw you the first time. We'll stop talking at that. Ms. Burchick, I will release you to pretrial, level 2 pretrial. These are all drug charges. It's gonna include random drug testing.
I have a question.
On the
I'm
felony,
not from,
just on the felony.
I'm not from Florida, and I'm not know what pre-trial means.
Oh, okay. All right.
I'll give you a call and explain it to you.
Okay.
All right. All right, good luck, ma'am.
Thank
Yes.
you, Your Honor.
On the felony matter, yes. Yeah, no, just the felony. There's a,
Thank you.
no, on all of the felony and misdemeanor, I'm sorry. All right. Erica Lovesmith. Did we do that one?
North Broward, Your Honor.
All right, Ms. Lovesmith is before the court for a second look on her bond status. She has a $1,000 bond on a possession of cocaine charge. It's a third-degree felony.
Yes, Judge, I'm going to be asking for an ROR for Ms. Lovesmith. She's been living here for 12 years. She's been staying in the same location for 9. She's been working on a research study for a nonprofit organization. I know that she does have several contacts with the criminal justice system in the past, but she does have long-term ties to the community as well. And pretrial release with mandatory drug testing, I think, Judge, would assure all parties that Ms. Lovesmith would be returning to court.
The problem is, Judge, her last case she had, she was placed on pretrial. She was ordered to go to First Step Sober House. She just took off from First Step Sober House. They didn't know where she was. Pretrial didn't know where she was. Judge Duffy had to sign a no bond warrant until she was ultimately picked up whenever law enforcement came into contact with her.
Right, and, these allegations are hand-to-hand transactions. I'm not gonna make any change on Ms. Love Smith's, bond status today. Good luck, ma'am. Tyree McNeil,
Don't believe he's in custody, Judge.
he's not in custody?
I think that he was, let me see.
Yeah, he posted bond and he has bond plus GPS.
Oh, okay. Daniel Vidrine,
Main jail.
He's approaching, Judge.
Mr. Vidrine was before the court on, February 25th, 26th.
Judge, correct. He's being held on $1,000 bond on a possession of heroin. Unfortunately, he's financially indigent. He's homeless. He does have a mailing address as far as where he can get future court notices, and that would be in Fort Lauderdale. The residence belongs to his mother. Right now, he's not working, and there's no one that can post monetary bond. So, Judge, we're going to be asking for the court to consider releasing Mr. Veldrine on standard pretrial release, and we wouldn't object to him having to be submitted to random drug testing.
I suspect the reason Your Honor took no action is because at the time of this arrest, he was on probation for domestic violence battery before Judge McHugh.
All right, I won't make any changes as to Mr. Vidrine's bond today. Good luck, sir. And then Tina Lydell. She bonded. And then, and we said Darwin Mingo is not,
Yeah.
his medical reset.
Judge?
I'm sorry,
Do you
yes?
do you want to take Mr. Mingo off the second look docket at this point? Because considering that his first appearance is being reset also.
Right, I don't know why is that a second look?
Depending on what happens when he does have his first appearance, then he can always have a second look reset.
Sure. All right, Miguel Rivas. That's on the misdemeanor docket.
Conti, Your Honor.
There's Mr. Rivas.
It's a municipal ordinance, Judge.
Yeah. Mr. Rivas, you're brought back to court. You was arrested on February 3rd. Are you being held on something else, sir?
Do you have any other charges?
Do you have other charges?
Huh? Do you have any other charges?
No.
He's taking care of his other charges?
He had him at the time, but
Okay. So, Mr. Rivas, it looks like this is the only open case that you have left. It's an open container matter. Do you wish to resolve that case today? You have to speak, so.
Right.
Yeah? All right.
Yes.
Okay, so I will sentence you to a withhold adjudication and time served on this charge,
Yes.
and then it'll be over. Okay?
Okay.
All right, sir, good luck.
Yeah. Oh.
How about, oh, we did Heather Lewis already.
I think the only one left is Joseph Sullivan Smith.
All right, so Joseph Sullivan Smith. Do we have Joseph Sullivan Smith?
Yes.
He's not?
He's in Conti.
Oh, okay. All right, so Mr. Smith, was arrested, or he was arrested on February 25th, and he does have a bond of
It's $500.
$500. Why does it say MU?
MU is a DUI designation.
Oh, that's a new one. Okay. All right. So what's with Mr. Smith?
Mr. Smith, can you post $500 bond?
No, I don't know anybody in Florida. I just moved here. So no, I can't pay it.
Where do you live?
I stay at a shelter right now at the BOC in Hollywood.
How long you lived there?
About a month.
How long you been living in South Florida?
About four,
I'm sorry?
about 4 months. Since September.
Plan on sticking around?
Yeah, I came down here because my daughter's down here.
So you have family in the area?
No, just my daughter.
Okay. Do you live with your brother?
No, my daughter.
Your what? I thought you said your brother.
No, my daughter.
Oh, your daughter. Okay.
Yes.
How old is your daughter?
12.
So who does she live with?
Her mom in Orlando.
I don't have the. It's just a DUI. I don't have the probable cause on this one to refresh my recollection.
Well, it's pretty routine DUI. It doesn't look like there was any kind of accident. Mr.
No, it wasn't.
Sullivan Smith apparently going in and out of lanes, and he was stopped. There was an open container of beer in the car. Said he was going to pick up his girlfriend at her job. Odor of alcohol, eyes were bloodshot, speech was slurred. And according to the officer, he did not pass the field exercises. He did indicate to the officer that he might have some difficulty performing the test because he had been shot in the leg and in the foot. And he did not agree to take a breath test.
All right. Okay. I'll release Mr. Sullivan on standard pretrial. Sir, you must report to the pretrial release services within 24 hours of your release.
Okay.
And you need to make sure that you check your mail so you know when you have to come back to court.
All right.
All right, good luck, sir.
Thank you. Thank you, Your Honor.
You're welcome. I believe we've covered.
I have a Eugene Johnny, or Johnny Eugene.
Yeah, we did that.
Oh, we did? Oh, okay. Okay.
All right, thank you, everyone.
Thank you, Judge.